Hello, my name is Kenneth C. Wells. I am a graduate student at Full Sail University, and I will be giving my research case study on defamation. Now, what is defamation, you may ask? Well, defamation is any statement which can hurt a person's reputation. Statements that are false and can't be proven against someone that is published is called libel. Statements that are proven to be hurtful to the intended target is called slander. So, from personal observation, what these three statements mean, like if something were to be published either through a book or newspaper, magazine, television, or even social media that can't be proven to be true, then this can be a pure example of defamation. There are different elements of defamation, but these five are really specific to what the definitions and the types are. These different elements are statement, which are spoken written words, publication, which is any third party, being the reader or the observer or the hearer, hears, reads, or sees a statement that can hurt their reputation. Injury, person who is hurt by the statements, meaning that if they are physically, mentally, or emotionally hurt, they can sue for defamation. Falsity, actual false in the name, false facts. And unprivileged. Now, unprivileged, meaning that if the lawmakers approve of the privilege that is falsifying facts, then it would be considered unprivileged. However, if the statement is approved by the lawmakers, then it'll be considered a privilege. Now, examples of defamation, if you see from your top left, would include the two speeches that are on the CNN screen. During the Republican National Convention over the summer, there was a comparison between Michelle Obama's 2008 DNC speech and Melania Trump's RNC speech. And if you look at the two side by side, they're almost alike. Now, the real question was, could Michelle Obama sue for libel? That she could sue for defamation because Melania Trump did not, well, number one, she did not obtain permission from Michelle to use it, and she did not also have the best put this, she did not have the written consent. So if I were to go backwards, then the element of defamation would be a statement of defamation, since she was able to speak the words from the speech, a publication because we as the listeners heard it, and there could also be injury, which I doubt, but there could have been. On your far right, this is just a joke, but this is not to take any pot shots at Cowboy fans, but memes. Memes on the internet could be a form of defamation, whether it's targeted at certain groups or parties or a person. If said groups, parties, or persons do not find this comfortable, then they can sue for defamation. And probably the biggest form, depending on the perspective you see, Wikipedia can be a form of defamation, because since Wikipedia can change at any given moment by any person, they can easily edit a page and put in falsifying facts about person, places, events that any person, that said party can sue for. The first case that I'll be talking about is the New York Times versus Sullivan. The case started in 1963, came to a decision in 1964. This case involves the New York Times covering a story about what the actions of the South was going on during the Civil Rights era. the one-page ad that was created was called They're Raising Voices. Now, at the time, there was a lot of evil, according to New York Times, that was going on in the South, especially around Alabama. And when the word got to L.B. Sullivan, who was the plaintiff, he believed that the New York Times was trying to take a shot at him by attacking his character and falsifying facts about what was going on in the South. So Sullivan decided to sue them for defamation, even though the New York Times never specifically. Now, Sullivan had a reason to sue because, according to the Supreme Court of Alabama, the New York Times never specified they were targeting. And since the Times couldn't specify which members or citizens participated in the acts that occurred during these different actions, such as these bombings and church bombings and everything included, Sullivan was awarded in full. He received over $500,000 from the jury. So New York Times eventually appealed the decision of the South Carolina Supreme Court and took it to the United States Supreme Court after being approved of a writ of certiorari. So what is a writ of certiorari? Now this is from the Latin word certiorari, which means to be informed of re-examination. So the process is that the Supreme Court will hear from the lower courts, and if the lower courts could not come to a decision, they will report it to the U.S. Supreme Court. If four more judges agree to the writ, then it can be taken to the Supreme Court for a re-examination. Now, the decision that came from the Supreme Court was that the New York Times was protected by the First and 14th Amendment because of the freedom of speech. In addition, the New York Times was not specifically going after Sullivan. Instead, it was creating an open and public discussion about the issues that were going on in the South without any intent of any evil. And since the Supreme Court of Alabama and Sullivan couldn't prove any actual malice towards them, then there would be no award claimed for Sullivan. Now, this was the first of many cases to actually study actual malice in the courts. The next case would be Gertz versus Welch, which the case started in 1973, and the decision came in 1974. The background behind this was that a magazine company that Robert Welch was working for was sued for attacking Carrot and providing false facts about Elmer Gertz. Now, this case would be one of the establish getting monetary awards for private parties who can actually prove a defamation against said organization or parties. The two parties that were represented in this case were Elmer Gertz and Robert Welch. Elmer Gertz, the petitioner, was a lawyer who was representing a family whose son was shot by police. Now, Gertz believed that the comments that were made by Welch about being a communist and a Leninist was attacking his character and decided to sue for defamation. Robert Welch, a reporter at American Opinion, wrote national stories of how communism was beginning to take over the United States, especially those who were working on the police force. He, as in Welch, reported that Gertz had a lengthy criminal record as well as being a communist sympathizer without actually verifying it with Gertz. So, how was this truth found out? Well, it turned out that American Opinion was, simply an opinion. The magazine in itself was just a publication that opened up public interest. Something for, people like you and I to talk about in terms of conspiracy theories, something that will intrigue the American people. That's why we have publications like the National Enquirer now, where even though some of their stories have fact to them, it still creates a form of interest. And even though Elmer Gertz was a successful lawyer, many people who were on the case for libel didn't know who he was because he kept a low profile. And because he kept a low profile, the court, the Supreme Court ruled 5-4 that there was really needed to be actual malice shown. And since the the jurors, the jury didn't know who he was, then they couldn't actually prove actual malice against Gertz. So Welch was in the clear. However, there was much to be needed, saying that he needed some form of actual proof to show that there was actual malintention, which there were none. In the state of Virginia, there are three elements that can create a defamation claim. The first element is publication, second one, statement, and third, injury. Now, to be called a defamation, the statements must be false and harm the plaintiff and the community or to those around him or her, meaning family, friends, or anyone within a close connection to the plaintiff. Now, defamation can be called in statements by the following: attributes to the plaintiff, the commission of some criminal offense involving moral turpitude for which the party, if the charge is true, to be indicated and punished, meaning that if the plaintiff were to be involved in something wrong, then that could lead to a defamation case. Meaning, if us, the plaintiff, the person who did it, meant it as a criminal offense. Indicate if defamation can be in a form of indication in which the plaintiff is affected with a contagious disease. Injury. Attributions to the plaintiff unfitness to perform the duties of an office or employment of profit or lack of integrity in the discharge of the duties such as an office employment or hurts the plaintiff in her profession or trade. Injury. So this result of these 5 bullet points came from the ruling of Fleming versus Moore in 1981, which was in the state of Virginia. Public and private limited persons figure. What this is basically determining whether or not you qualify for a person that can or cannot be sued by defamation. Now, there are 5 different figures that can determine whether or not you will qualify or not. Basically, in a synopsis of all 5, if you were involved in something where you were personally involved in damaging or changing the outcome of an event or events, then this could ruin your chances of seeking that limited person's figure. Meaning you'll be more acceptable to being sued for defamation. Actual malice in the state of Virginia is, for all practical purposes, any form of intent that was set to bring danger or any negativity in order to earn compensation. Meaning that if you were to publish something and you actually meant to cause actual intent in hurting someone, either via statement, falsify, injury, or an unprivileged quote, then you can be sued for actual malice. In the Commonwealth of Virginia, there are 2 ways to counteract defamation. One is privilege and one is defense. Now, the ultimate privilege is truth. If you have the truth, then you win against any form of defamation. Also known as substantial truth, which if you can provide anything that's factual, then you will more than likely win your case. Fair opinion and comment privilege. Basically, everyone's entitled to an opinion. Everyone's entitled to their own feelings. And if they are true, and if they are fair and they are just, then that also can serve as an advantage to you. Fair report privilege is basically if you have the facts, if you have stats to show that the report or whatever you're presenting is factual, then this privilege will be given to you in the courts of Virginia. Now, the statute of limitations is that a person has only 1 year to report a defamation suit in the state of Virginia. Now, what I learned from the New York Times versus Sullivan, as well as the Gertz versus Welch Inc. cases, is that number one, you gotta get the facts. Fact checking is everything, and especially if you are in the journalism world, where there's been a lot of instances where many of people who report news don't get the facts, or they only see things one-sidedly, it tends to affect a lot of things. So if you get facts from both sides, it will help create a sense of balance for your reporting. Number two, well, I think this one can easily tie in for number one as well, is tell the truth. Tell them the truth. That's all you basically can do, is just to give fair and honest opinion, but to be actually truthful at the same time. And the third thing that I learned is to look, listen, and observe. So basically, what I have to do personally is, you gotta listen out, you gotta look, and you gotta observe, because what some people may say about a certain issue may not be agreeable with others. But if you listen, look, and observe with people from both sides of the spectrum, especially when it comes to politics, then you can develop your own truth from what you've heard and listened. And so, judging by these two cases, the actual malice and truth are two things that are strongly debated upon. People, and myself included, have to pay attention to the facts in order to gain the truth. Thank you for listening to this. It may not have been as plain as I wanted to, but it was fun learning about these two cases, and I hope I can do it again soon. Thank you.